Welcome. It's wonderful to see so many friends and supporters and colleagues here tonight. I have a brief and welcome job, but a difficult one, because it is very hard to introduce a close friend. At least it's hard for me, because I want to do my friend, and you will excuse me, justice. I want to tell you everything about his career as a reformer, teacher, scholar, a leader so prominent that just last year he was named the most influential person in legal education, which not a single person in legal education needed the poll to know. I want you to know what I know. Beyond his long list of accomplishments that are just briefly summarized in your program, beyond the 10 books and hundreds of articles, beyond being one of the most highly cited constitutional law scholars in the nation, beyond having a speaking schedule that touring rock stars would be jealous of, or a Google search that produces 119,000 results in 1.5 seconds. What I want you to know is that he is a lifelong student who as a young man was drawn to the law during the civil rights movement, and who still believes to this day in the power and possibility of social change. That he is a scholar and teacher who can take others into the most contested, most controversial, most difficult waters and navigate successfully. He's a speaker who thinks in paragraphs and speaks in paragraphs and can not only recite and debate cases, but to those of us who even partially work in his field are astounded when he not only cites cases but can debate footnotes just out of the air. A public intellectual who can still identify the oak undertones of fine wine. A person who always seems genuinely surprised when friends like me recount all of his extraordinary accomplishments as a great leader. A newspaper reporter once referred to him as a soft-spoken man with understated but unmistakable gravitas. A brief story is how Erwin navigated the start of his first and famous founding deanship at UC Irvine. California politics are, at times, Caesar Borgia's Italy to Arizona's Athenian democracy. I understand why you're laughing, but it's a fair comparison. Erwin found his offer of the founding deanship challenged in a way that was both murky and fully in public view. He was offered the job, offer was withdrawn, a hurricane of support came from across the political and ideological spectrum. The hidden critics retreated and placed the blame on Irvine's chancellor. Public calls came for Erwin to be again offered the deanship, but only on the condition that the chancellor be gone. In a move reminiscent of neither Venice nor Athens, and more in the spirit of Nelson Mandela, Erwin said he would graciously accept the challenge and opportunity to be Irvine's founding dean, but only on the condition the chancellor remain. He has been a great friend to me and to my family. He's also been a friend to our college at a key moment in our history, indeed a key moment, I think, in legal education. We were changing the law school admissions process to be more accessible. It was Erwin who instantly, and I literally mean instantly, I mean minutes after a phone call, led the defense of our college and its innovative spirit. And by giving his focused and powerful voice to our efforts, he brought along, and again I mean this literally, the entire profession of legal education to our support. Please join me in welcoming Erwin Chemerinsky in a conversation with Professor Andrew Cohn.
I've been fortunate to be introduced a number of times in my life. I don't think I've ever been this touched by an introduction as then. It means so much to me that you would say those things. And it's enormously special for me to be here. And as I was saying to Tony a few minutes ago, anything that Tony and Mark would ever ask me to do, I would immediately say yes to. They're some incredibly special people, and Mark, dear friends. And you're so unbelievably fortunate to have Mark as the dean of this law school.
Thank you, Mark. Thank you, Tony. Welcome, Erwin. This evening, Dean Chemerinsky and I will be discussing his recent book, Closing the Courthouse Door: How Your Constitutional Rights Became Unenforceable. Why did you write this book?
If the Supreme Court were to say that the government can give unlimited amounts of money to parochial schools, that would be headlines of every newspaper. But if the Supreme Court were to say no one has standing to challenge the government's aid to parochial schools, few would pay any attention to that. And yet, the effect is exactly the same in terms of real-world impact. And one of the things that became apparent to me as a teacher, a scholar, a litigator, is how much the Supreme Court over the last decades has closed the courthouse doors. And the result is that people who have been seriously injured, whose most precious rights have been violated, have no opportunity for redress. And if there's no remedy, it's as if the right doesn't exist. And I wrote the book to tell that story.
I'd like to start with a few background questions to orient the audience. What is the purpose of a constitution?
Obviously, the Constitution exists to create the government. Any constitution does that. But I also think the Constitution exists to limit what the government can do. That's particularly true of the United States Constitution. The Constitution came about only after the failures of the Articles of Confederation. Creating a national government was thought of as a necessary evil. And the framers of the Constitution were just as concerned about limiting federal power as empowering the federal government to be able to act. And so I think that the Constitution exists to restrict what the government can do, especially in times when the majority might want to do something else. There's something profoundly anti-majoritarian about our Constitution, or about any Constitution that would succeed. Think about it. What makes the Constitution different from all other laws? Any other law can be changed by the majority of the legislature. Any law passed by Congress, that or another session of Congress can change. Any law adopted by the Arizona State Legislature or the Tucson City Council can be changed by the Arizona State Legislature or the Tucson City Council. But to change the Constitution takes 2/3 vote of both houses of Congress and 3/4 vote of the states. At least it was the procedure that's always been used to amend the Constitution. The Constitution has been amended only 17 times since 1791. And then you have to ask, why would a nation that thinks of itself as a democracy want to be governed by a document that's so difficult to change? None of us obviously played any role in ratifying it. Most of us didn't have ancestors in this country who played any role. And my answer to that question then becomes how desirable it is to put our most precious values, the structure of government, individual rights, in a document that's difficult to change. I think it's being anti-majoritarian, also very concerned with protecting the rights of the minority. The majority usually doesn't need a constitution to protect it. It can use the political process to protect itself. It's minorities who need that protection. And so I think that's another key function of the American Constitution.
Why do we have federal courts?
There was a debate at the Constitutional Convention in 1787 about what to do with regard to the federal courts. Under the Articles of Confederation, there weren't federal courts. It was quickly agreed at the Constitutional Convention that there should be a United States Supreme Court. But there was disagreement as to whether to have lower federal courts. Some believed that it was unnecessary to have lower federal courts. We could just have state courts in the United States Supreme Court. Others believed that it was essential to have lower federal courts, that too often state courts might be parochial. They might favor their own citizens over out-of-staters. They might favor their own state interests over national interests in the Constitution. And so, unable to resolve that dispute, the framers punted. They said, we'll just leave it to Congress to decide. And the Constitution in Article 3, Section 1 says that there'll be a Supreme Court and such lower federal courts as Congress ordain and establish. But since the first Judiciary Act in 1789, there's always been lower federal courts. And I think it's based on the recognition that however wonderful the state judiciaries are, there's times when they're going to be or be perceived as parochial, biased for in-staters over out-of-staters, favoring state interests over national interests in the Constitution. So if you ask me why we have federal courts, it's to enforce the Constitution and laws of the United States above all else.
What makes federal courts especially well suited to this role of enforcing the Constitution?
Article 3, Section 1 also says that the justices of the Supreme Court and whatever courts Congress will create shall have life tenure. They have their positions for life unless they're impeached or resign, and their salaries can't be decreased during their term of office. And I think that's absolutely essential to ensure judicial independence and to enforce the Constitution. I also think that role matters enormously in behavior. Social psychologists have long told us how if you assign somebody a role, it powerfully influences how they perform. We've said from the beginning one of the key roles of the federal courts is to enforce the Constitution and enforce federal law.
In the book, you identify a number of doctrines that deny remedies to persons whose constitutional rights have been violated. I'd like to quickly run through several of them. What is sovereign immunity?
Sovereign immunity is the principle that the government cannot be sued except with its own consent. It actually comes from English law and the maxim that the king can do no wrong. So to make this specific rather than abstract, the United States government cannot be sued except to the extent Congress has passed a statute authorizing suits against the United States government. State governments cannot be sued except to the extent that they consent to be sued, or a few other minor exceptions. I think sovereign immunity is at odds with the Constitution. It puts the institution, government, the United States state governments, above enforcing the Constitution. The Constitution says in Article 6 that the Constitution, laws, and treaties made prescriptive are the supreme law of the land. And sovereign immunity means that the government can violate the Constitution and not be held accountable.
What is qualified?
Whenever an individual government official is sued for money damages, he or she always has as defense immunity. Some of government officers for particular tasks have what's called absolute immunity. That means they can't be sued for money damages at all. Judges for their judicial tasks have absolute immunity. There's what I think is an egregious Supreme Court case, Stump versus Sparkman. It involves a woman in Indiana who went to see a judge in his chambers. She said she was worried about her teenage girl, her daughter. Said her daughter was staying out at night. She was worried her daughter was getting in trouble. And she asked the judge to sign an order to have a surgical sterilization performed on her daughter. The judge had no authority under Indiana law to order this. No case was ever filed in the judge's court. No docket number was ever assigned. No notice was ever given to the girl. No hearing was ever held. The judge signed the order. The girl was told she was having an appendectomy. Only many years later did she learn that a tubal ligation was performed when she was married and unable to conceive a child. She sued the judge. The Supreme Court ruled 5-4 in an opinion by Justice Byron White that the judge had absolute immunity to civil suits for money damages. The judges can't be sued for what they do as judges. Prosecutors have absolute immunity for their prosecutorial tasks. So, this case Imbler versus Pashman from 1976, that involves a prosecutor who knowingly used perjured testimony that led to the conviction of an innocent person. So 9 years in prison. When ultimately the real culprit was found and convicted, the individual sued the prosecutor. The evidence was overwhelming that the prosecutor knew that he was using perjured testimony. But the Supreme Court said prosecutors have absolute immunity and can't be sued for money damages for what they do in that role. Legislators have absolute immunity for their legislative tasks. The president has absolute immunity for acts taken in carrying out the office of president. Police officers have absolute immunity for the testimony they give as witnesses. If a police officer lies on the witness stand and leads to the conviction of an innocent person, the police officer can't be sued for money damages. There's absolute immunity. That was the holding of Briscoe v. Who in 1983. For all government officers who don't have absolute immunity, they have what's called qualified immunity. That's how I answer your question. And the Supreme Court has said that a government officer can be sued for money damages, qualified immunity overcome, only if it's proven that the officer violated clearly established law that every reasonable officer would know, and it has to be a right that's established beyond dispute. Again, I know that sounds abstract, so let me give a concrete example, and let me give one from the state of Arizona. It was a case not long ago, Safford Unified School District versus Redding in 2009. It involved a middle school student, Savannah Redding. She was suspected of giving prescription-strength ibuprofen to another student in the school. One of the things that I learned as a result of this litigation is that the only difference between prescription-strength ibuprofen and regular-strength ibuprofen is the amount in the capsule. That any of us can take prescription-strength ibuprofen just by taking several regular-strength ibuprofen. Savannah Redding was taken by two female school officials into a classroom. She was ordered to remove all of her outer clothes. She was ordered to pull out her bra and underpants so the school officials could peer in and see whether or not she was hiding ibuprofen. She wasn't. Her parents sued the school officials who did this. Now, school officials don't have absolute immunity, but they're only liable for money damages if you overcome qualified immunity. The Supreme Court ruled 8-1 that strip searching Savannah Redding violated her Fourth Amendment rights. But in the same opinion, the court ruled 7-2 that the school officials could not be held liable for money damages because they didn't violate a clearly established law that every reasonable law should know. They said the law wasn't clear that strip searching in this context violated the Constitution. Now, I would question that. I would agree with the dissent. Shouldn't any school official know that what was done here was degrading and unconstitutional? But this is an example where qualified immunity prevented liability. And I can go through so many examples in recent years, and obviously present some in the book, where qualified immunity meant that government officials who violated the Constitution could not be held accountable. And more important, those who were injured were left without any remedy.
Unlike federal and state governments, local governments are not formally immune from suit, but it is still very difficult to sue them successfully. Why?
In 1978, in Mandala versus Department of Social Services, the Supreme Court held that a local government can be held liable only if its own policy violates the constitutional laws of the United States. It can't be held liable on the grounds that an employee is acted in violation of the constitutional laws of the United States. For any other kind of employer, if an employee in the scope of his or her duties injures people, the employer is liable. If a UPS driver, while on the job, hits somebody and injures the person, UPS is liable. There's even a name for this in law. It's called respondeat superior liability. It just says an employer is liable if an employee injures people in the scope of the employee's duties. But in Mandala versus Department of Social Services, the Supreme Court said that local governments can't be held liable on that basis. Local governments can be held liable only if you can prove that they have a policy that violates the Constitution. So imagine a police officer uses excessive force. Police officer kills somebody in the line of duty. You can only hold the local government liable if you can prove that the local government had a policy that caused that. You immediately can see how difficult that would be to accomplish.
What is a Bivens action?
It might surprise you that if the government violates the Constitution, you generally can't sue right under the Constitution. You might think if the Tucson City Council violates your First Amendment rights, you just sue them for violating the First Amendment, right? Or a police officer conducts an illegal search, you sue the police officer for violating the Fourth Amendment. But it generally doesn't work that way. there usually needs to be some law that allows you to sue. And when it comes to local governments and state and local officials, the law that allows suit was adopted in 1871. At the time it was called the Ku Klux Klan Act. It's codified now as 42 United States Code, section 1983. And any time you want to sue a local government for violating First Amendment rights, or a state or local police officer for excessive force, or anything else in terms of constitutional violations, and often violations of federal law, you file a 1983 suit. And 1983 is simply a statute that allows you to sue to enforce the Constitution. Virtually all constitutional litigation in the United States against local governments or state or local officials is brought as a 1983 suit. But there is no similar statute that authorizes suits against federal officials. And in 1971, in Bivens versus 6 unknown named agents of the Federal Bureau of Narcotics, the Supreme Court said it would allow a suit against federal officers right under the constitutional provision itself. Again, to make this less abstract and more concrete, agents of the Federal Bureau of Narcotics went into Wesley Bivens' house in the middle of the night. They conducted an incredibly abusive search. They made him stand naked while they ransacked the place. He wanted to be able to sue. He couldn't sue the United States government because at the time there was no statute that would have allowed that. So if he wants any remedy, you think, well, he's got to be able to sue the federal officers. But there's no statute like Section 1983 to allow a suit against federal officers. And so he sued under the Fourth Amendment. And the Supreme Court, in an opinion by Justice William Brennan, said that when it comes to federal officers violating here the Fourth Amendment, a cause of action, a claim for money damages would be inferred. Justice Harlan wrote a concurring opinion. He said, for people in Bivens' shoes, it's damages or nothing. And therefore the court wanted to create a damage remedy. Now, the problem with this, when they get to it, is that since 1980, which is now a long time ago, 38 years ago, the Supreme Court has continually cut back on Bivens. In fact, has not ruled in favor of the Bivens suit during those 38 years.
What does Article 3 stand in?
I feel like we can teach the whole federal courts.
In half an hour.
It feels like a good final exam question. Article 3, Section 2 lists the kinds of cases that federal courts can hear. It has been established since early in American history that a federal court can only hear a case if Article 3 allows it. There also has to be a federal statute that authorizes it. And federal courts can't hear anything unless Article 3 permits it. Even if the parties consent and want to go to federal court, unless Article 3 permits it, unless there's a federal statute, the federal court just can't hear that case. Article 3, Section 2 lists 9 types of matters that federal courts can hear. In each of those 9 categories is preceded with the word cases or the word controversies. And the Supreme Court has interpreted those words, cases and controversies, to give rise to a series of limits on what federal courts can hear. And one of those limits is what you just referred to, standing. The Supreme Court has said, standing demands that a person show a sufficient personal interest in the outcome of the case so that the person should be able to come to court. And so, in order for someone to have standing to sue a federal court, the person has to show that he or she has been personally injured, that the injury has been caused by the defendant, and that a favorable court ruling is likely to remedy the harm. Again, I worry this sounds so abstract, so let me give you a concrete example. It's a case called City of Los Angeles versus Lyons from 1982. Adolph Lyons was at the time a 24-year-old African-American man. He was stopped by a police officer about 2 in the morning throwing a burnout taillight. The officer ordered Lyons out of his car. Police could order people out of the car when they lawfully stopped them. And the officer slammed Lyons' hands above his head. Lyons had his keys in his hand, so the fact of slamming his hands on the roof of the car was the keys were cutting into the skin of his palm. He complained of this to the officer. The officer then administered a chokehold on Lyons, literally put his arm around Lyons' neck and choked him until Lyons became unconscious. Lyons awoke. He was spitting blood and dirt. He had urinated and defecated. The officer gave Lyons a traffic ticket and let him go. Lyons did some research and he discovered to that point 16 people in Los Angeles, almost all like him African-American men, had died from police use of the chokehold. Lyons sued the city of Los Angeles Police Department, for an injunction to keep the police from using the chokehold except where necessary to protect the officer's life or safety. But the Supreme Court ruled 5-4 that Lyons lacked standing to seek an injunction. The Supreme Court said Lyons could not show that he personally was likely to be choked again in the future. The Supreme Court said a plaintiff like Lyons, who wants an injunction, has to show that he or she is likely to be personally injured again in the future. Think of all the things that the government might do. We know it'll harm somebody, but we can't know who. The effect of Lyons is you can't have standing in those instances.
So I want to ask you just about one last doctrine.
Okay.
I want to emphasize to the audience that I don't think we'll even have gotten through half of the court-limiting doctrines that are discussed in the book, but we'll keep it short here for tonight. What is the political question doctrine?
The Supreme Court has said that there are certain constitutional provisions that won't be interpreted and enforced by the federal government, the federal courts. There are certain constitutional provisions that are left to the other branches of government, the political branches of government, to interpret and enforce. Let me give you some examples of this. There's a clause in Article 4, Section 4 of the Constitution that says the United States shall guarantee to each state a Republican form of government. This has nothing to do with political party. The framers thought that a Republican form of government was one where people would elect representatives and the representatives would then make the laws. Ever since the 1840s, the Supreme Court has said that cases under the Republican form of government clause are political questions. The courts won't adjudicate it. Let me again give you a concrete example. I think that partisan gerrymandering is one of the real threats to our democratic system. I know Arizona has an independent district and commission. California does. But Arizona and California are in the minority here. Partisan gerrymandering, of course, is where the political party that controls the legislature draws election districts to maximize the seats for that party. It's not a new practice. It takes its name from a governor of Massachusetts early in American history, Elbridge Gerry, who engaged in the practice. But what's changed now is that it's possible to engage in partisan gerrymandering with far more precision and accuracy than ever before. Sophisticated computer programs and longitudinal studies mean that partisan gerrymandering can be far more successful. We all learn, maybe in a civics class, that its voters are supposed to choose their elected officials. But the effect of partisan gerrymandering is the elected officials get to choose their voters. In 2004, in Veith versus Jubileer, the Supreme Court said federal courts can't hear challenges to partisan gerrymandering. That poses a political question. I'll give you another example. The Supreme Court has said that challenges to the president's conduct of foreign policy pose political questions. There's a famous case involving Arizona Senator Barry Goldwater. President Jimmy Carter rescinded the United States treaty with Taiwan as part of recognizing the People's Republic of China. Senator Goldwater brought a lawsuit and said, just as the Senate has to approve a treaty, so should the Senate have to approve rescission of a treaty. When it comes to repealing a law, Congress has to be involved there, likewise involved in rescission of a treaty. But the Supreme Court said, this is a challenge to the president's conduct of foreign policy. The courts won't adjudicate. So even if what the president was doing was unconstitutional, no court could hear the matter. When George W. Bush was president, he rescinded the anti-ballistic missile treaty with Russia. No court could hear a challenge that, even if what the president was doing was unconstitutional.
How would you sum up the cumulative impact of the doctrines that we've just discussed?
Each of the doctrines that we've talked about means that people whose rights are violated won't be able to have access to the courts. They won't be able to get a remedy. There isn't a way to hold the government accountable. And if you add all of these together, and there are others in the book as you point out, it means that we're really undermining the Constitution. It means we're really closing the courthouse doors. And it may be that you're familiar with some of the doctrines we're talking about, maybe many of them, but it may also be that these are doctrines that aren't familiar to you, because I started by saying, these aren't the things that make headlines. The front page of the New York Times doesn't write about the political question doctrine, or about the 11th Amendment and sovereign immunity, or about qualified immunity. And that's what to me makes it so insidious. It's taking away our rights without our realizing it by depriving us of any remedy when they're violated.
What should the Supreme Court do differently?
All of the doctrines that I've described are judicially created. Some come from the court interpreting the Constitution, like standing that comes from Article 3. Some come from the Supreme Court interpreting statutes. I would have liked to see the Supreme Court change the constitutional doctrines and see Congress change the statutory doctrines. Now, I tell you that the book has a 2017 publication date. It was finished a year before that, as you know so well with your book. It takes about a year after you finish the manuscript before you have the joy of holding the bound volume, the book. And so I finished the book at a time when I thought there might be an ideological shift on the Supreme Court. And almost all the cases that I've described to you were 5-4 decisions. Almost all were split along ideological lines. Beath versus Jubileer was 5-4 with a 5 conservative justice majority. Lyons versus Los Angeles was. Stump versus Sparkman was, and so on. And so I wrote the book focusing on what the Supreme Court should do differently and what Congress should do differently. And I end each chapter with very specific prescriptions for how to change the law. Obviously, we don't have that ideological shift on the court, and it's less likely that these changes are going to come about in the years ahead.
Let's discuss some counter-arguments. Without immunity from suit, the police and other government officials will be afraid to do their jobs, which are difficult, which are important, and which pay little compared to the private sector. This would make us all worse off. How do you respond?
The choice isn't no liability or strict liability. There are middle places that we could choose. So I would say, for instance, if a police officer commits a deliberate wrong, lies in court, commits perjury, there I would move towards no immunity whatsoever. But if a police officer is exercising reasonable discretion, then I would provide the police officer immunity. So I think that my response to the question is, I think it makes a false assumption that we have to choose between no immunity and total liability. And I want to provide police protection for what they're doing, but I don't want to provide the protection for lying in court.
In defense of the political question doctrine, Yale law professor Alexander Bickel observed that no society can fail in time to explode if it is deprived of the arts of compromise, if it knows no way of muddling through. Don't the courts need some way to avoid deciding cases that, for whatever reason, other actors are better suited to decide?
Again, I think that the question has a false assumption that it's the judiciary decides everything on its own, or the judiciary decides nothing. The judiciary often can and does defer to the judgments of other branches of government. When it comes to matters of foreign policy, the court can decide to give deference to the expertise of the executive in conducting foreign policy. But I reject the idea that there should be constitutional provisions where the federal courts can never hear challenges under them. Marbury versus Madison in 1803 told us that the Constitution is meant to limit government, and those limits are meaningless unless they can be enforced. And where the Supreme Court says there's a constitutional provision that can't be adjudicated by the federal courts, where cases are always a political question, that's the same as reading the provision out of the Constitution. The Constitution is the same as if there wasn't the provision in Article 4 that says the United States shall guarantee to each state a republic of pro-government. The court has made that a meaningless provision, and I don't think there should be meaningless provisions in the Constitution.
Without the immunity and the standing doctrines, you criticize the federal courts will be overwhelmed by a flood of litigation. True or false?
I think it's false, and I don't think it matters. I think it's false because the reality is litigation is expensive, and there are plenty of techniques that courts have for managing their doctrines. But also, the assumption of the question is that expediency, saving resources, is more important than enforcing the Constitution. If eliminating these doctrines really leads to a lot more cases, let's create more federal judges. But let's not leave the Constitution unenforced for the sake of efficiency.
Without sovereign immunity, states will be demoted from co-equal sovereigns to mere field officers of the federal government, without the dignity and the stature required to fulfill their constitutional role as counterweights to federal power. How would you respond?
Article 6 of the Constitution says, the Constitution and laws and treaties made pursuant are the supreme law of the land. If a state can violate the Constitution or federal law and nowhere be held accountable, then how do we ensure the supremacy of federal law? Let me give you an example that I'm very focused on right now. It's a case called Franchise Tax Board versus Hyatt. I focus on it because I'm going to argue it in the Supreme Court the first week of January. And my brief is due in the Supreme Court November 15th, and I'm determined to finish the first draft of my brief by the end of this weekend. My client's Gilbert Hyatt. He's an inventor. He has many patents. He moved from California to Nevada in 1991. The Franchise Tax Board, which is responsible for collecting taxes in the state of California, thought it was a sham move to evade taxes. And they went after him in every way they could. And the person who was responsible for the investigation said very anti-Semitic things about him as to why they're going after him. And they invaded his privacy, his property, they defamed him, they revealed private information about him publicly. He sued the state of California, the Franchise Tax Board, in Nevada State Court. Now, sovereign immunity, which we've been talking about, means a state can't be sued in federal court. The Supreme Court said in 1999 in Alden versus May that a state can't be sued in its own state court. But the one area where sovereign immunity doesn't preclude suit is a state can be sued in another state's courts. That's a Supreme Court decision, Nevada versus Hall in 1977. So Gil Hyatt, resident of Nevada, sues the Franchise Tax Board in state trial court in Nevada. The jury awards him $389 million in damages. That counts compensatory and punitive damages. And that's a reflection of how truly egregious the conduct against him was by the Franchise Tax Board. And I could go on and on and on in detailing the things that they did to him. The Nevada Supreme Court largely affirms the jury verdict, both as to liability and damages. To make a long story short, and this is the third time this case is going to be before the Supreme Court, the issue that's now before them, and it's the only issue presented in the case, is whether Nevada versus Hall should be overruled. If Nevada versus Hall is overruled, then how can people who are injured have any remedy against state governments? The Supreme Court ruled in 1999 that a state government can't be sued for patent or copyright infringement. The example I give to my students is, imagine a constitutional law professor who has a casebook textbooks that are used at a number of law schools. Imagine a professor at a state university rather than have the students buy this book, simply copies it and distributes to the students for free. And imagine also this hypothetical law professor is saving the book royalties for his 4 children's college education. The hypothetical law professor is out of luck. You can't sue the state because the state has sovereign immunity, and suing the individual professor, because we talked about earlier, qualified immunity. So I think if we're going to take seriously enforcing the Constitution and the laws of the United States, when state governments violate it, there has to be a remedy. There must be a forum. And that's why sovereign immunity, I think, is inconsistent with the principle of the Constitution. And that's what I'm going to try to argue to the Supreme Court in January, and why they shouldn't overrule the Danvers law.
So the principle that every right requires a remedy, which is central to the book, sounds awfully good in theory, but constitutional rights are to a large extent in the eye of the beholder. Guaranteeing a judicial forum for every constitutional claim simply allows 5 unelected judges to impose their views on the rest of us. Here I'm just channeling the possible objections to your argument. Given the present composition of the court, that's likely to be good for wealthy individuals, big businesses, conservative Christians, and bad for labor unions, the poor, consumers, and racial and religious minorities. Think of cases like Janus versus AFSCME, Citizens United, Shelby County versus Boulder, parents involved in Gratz versus Bollinger, not to mention Lochner versus New York, Carter Cole, Hammer versus Degenhardt, and the civil rights cases. How would you respond?
I agree with all of your examples. In fact, I wrote a book a few years before this one titled The Case Against the Supreme Court. And the thesis of that book is that the Supreme Court has often failed through American history, often in the most important tasks, the most important times. The question is, what conclusion do we draw from it? Some scholars draw the conclusion that we'd be better off without having a Supreme Court with the power to strike down government actions. That we should leave the enforcement of the Constitution to the political process. Mark Tushton, who's a famous professor at Harvard Law School, wrote a book titled Taking the Constitution Away from the Courts, we argue for this. Larry Kramer, who was a law school classmate of Dean Miller, wrote a book calling for popular constitutionalism and the end of judicial sovereignty. James Rager Burns, who won a Pulitzer Prize, wrote a book a few years ago calling for the end of judicial review. It's tempting to come to that conclusion in light of everything you say, but I disagree. I think of the people who I've represented through my career as a lawyer. I argued a couple of death penalty cases in federal courts of appeals. I represented a Guantanamo detainee for many years. I represented a homeless man in Texas challenging the 10 Commandments monument that sits right in the corner of the Texas State Capitol and the Texas Supreme Court. I represented a person who was sentenced to 50 years to life in prison for stealing $153 worth of videotapes, California's 3 strikes law. And I realized for people like my clients, it's the courts to protect their rights or it's nothing. When was the last time a legislature adopted a law to give more rights to criminal defendants or do more to protect criminal rights? That it might be that my clients will lose in the courts. And I've lost many of the cases that I just mentioned here. But I don't think we can leave the Constitution's enforcement to the political process. And so I continue to believe that we're better off as a society having an institution like the Supreme Court, largely insulated from majoritarian politics, to give meaning to and to enforce the Constitution. And since at times I can be shameless, I'll plug my new book that's coming out in November. It's titled, We the People, A Progressive Reading of the Constitution for the 21st Century, in which I argue that even in the face of the conservative court that you described, conservative court for years to come, progressives should continue to believe in the Constitution and try to argue for how progressives should interpret and advocate for that document.
In the last few minutes, I'd like to look ahead. The Supreme Court is at a historic turning point. After Anthony Kennedy's retirement and Brett Kavanaugh's confirmation, the court lacks a swing justice for the first time in many decades. Going forward, most contentious decisions seem highly likely to break down along not just strictly ideological lines, but strictly partisan lines, with the 5 Republicans voting one way and the 4 Democrats, or 5 justices appointed by Republican presidents voting one way and 5 justices voted by Democratic presidents voting the other way, for the first time in the court's modern history. And to top it all off, 4 members of the current conservative majority were confirmed by senators representing a minority of the national population. 2 were appointed by a president who lost the popular vote. 1, Justice Gorsuch, was appointed to a seat that many Democrats believe was stolen from President Obama and his nominee, Merrick Garland. Another, Justice Kavanaugh, was confirmed over the opposition of a strong plurality of Americans after perhaps the most divisive judicial confirmation in American history. If the court's role is to serve as a check on popular majorities, does it matter that so many of the current justices were appointed and confirmed by officials representing a minority of the electorate? Might this even be a strength?
I'm less concerned that the justices were appointed by presidents representing a minority of the population than I am concerned by all of the things you mentioned that I think taint the legitimacy of the court in the public's eyes. Think of the 5, well, I'll start with what you point out quite rightly. This is the first time in American history, at least that I know of, where the ideology of the justices corresponds to the political party of the president who appointed them. The 5 conservative justices were appointed by Republican presidents, the 4 liberal justices were appointed by Democrats. That's a new phenomenon. Until recently, we had relatively liberal justices on the court, John Paul Stevens, David Souter, who were appointed by Republican presidents. We had conservative justices like Byron White or Felix Frankfurt, who were appointed by Democratic presidents. So I think this heightens the sense that the Supreme Court is just an extension of partisan politics. But then I look at what you talk about in a slightly different frame in terms of what it means with regard to how the public perceives the justices. Clarence Thomas was confirmed in 1991 by about a 52 to 48 under the cloud of lack of legitimacy that came from the Anita Hill hearings and the widespread perception that he flat out lied. In terms of John Roberts and Samuel Alito, they're likely on the court because of Bush versus Gore, that many regard as nothing more than the 5 justices saying, we want the Republican as president. Many regard as the most shameful decisions in American history. Neil Gorsuch. Prior to 2016, 24 times in American history, there had been a vacancy in the last year of a president's term. In 21 of 24 instances, the Senate confirmed. In 3 instances, the Senate denied confirmation. But never before had the Senate said, we're not going to hold hearings or a vote on a presidential nominee. Merrick Garland's nomination languished longer than any Supreme Court nomination in American history. It's the first time that a political party openly said, we're not going to allow a president to fill a vacancy on the court. We're going to qualify the nominee because we want to hold this seat open in case our party wins the presidency in the coming election. And then Neil Gorsuch was confirmed only because the Senate Republicans eliminated the filibuster for Supreme Court nominations. And whatever your perceptions from a couple of weeks ago with regard to the Brett Kavanaugh hearings, there's no doubt that his legitimacy is tainted. Beyond his ideology, beyond whether you believe that he was lying or telling the truth, never has a nominee for the Supreme Court made such a boldly partisan statement as he did when he came before the Senate Judiciary Committee on that Thursday afternoon. So I think all of this combines to undermine the legitimacy of the Supreme Court. I don't know what it's going to mean in the long term. I don't know what it means that the legitimacy of the other institutions of the federal government are at the lowest point in recent memory. We have a president, again, this isn't a partisan statement, but his approval rating is hovered around 35% throughout his time in office. For Congress, the approval rating is about 18, and I think that's 18 people, not 18. And for the Supreme Court, I don't know if this cloud with regard to legitimacy will mean that we'll have a point, like a constitutional crisis that occurred in the 1930s surrounding the Supreme Court, or if it's going to lead to a point where government officials feel more free to disobey court orders, or if the Democrats take the presidency in Congress in 2020, whether they'll try to increase the size of the Supreme Court. We just can't know at this moment what it's going to mean. But it certainly causes me to be very worried about the institutions of government and therefore the Constitution.
Let me try to end on what I suspect for you will be a slightly happier note. A number of conservatives, including University of Chicago law professor Will Bode and Justice Clarence Thomas, have recently criticized the doctrine of qualified immunity. Do you see anything coming of this? And are there any other bright spots on the horizon from your point of view?
I see no indication that the Supreme Court is going to reconsider the doctrine of qualified immunity or any of the other doctrines that we've talked about. Boulder wrote the article you mentioned, Clarence Thomas has questioned it, but what's gone on over the last decade is the Supreme Court has expanded the protections of qualified immunity, not suggested narrowing it. I think the bright spot is the long term. If you look at the course of American history, there's been such tremendous advancement of liberty and equality. Think just in relatively recent years, how we've gone from, in 2003, the first state recognizing a right to marriage equality to gays and lesbians, to 2015, the Supreme Court finding such a right under the Constitution. That's an enormous expansion of equality and liberty in a very short period of time. And I really believe that what Dr. Martin Luther King Jr. said was right when he said, the arc of the moral universe is long and it bends towards justice. So I have optimism for the long term, even if there's pessimism for the short term, especially as the things we talked about.
We have time for just a handful of questions here. Yes?
So Dean Chemerinsky, it seems like you take a decent amount of exception to the idea of sovereign immunity for state and federal governments. Do you think that the doctrine of sovereign immunity as applied to tribal governments should also be held to the same standard?
I know much less about Native American law than I do about the liability of the United States and state governments. And yet my position is that sovereign immunity is inconsistent with accountability. And so I would say that when it comes to an absolute principle like sovereign immunity, whether it's the United States government or state government or tribal government, I would oppose its existence. I think that there should be accountability when entities violate people's rights.
Thank you.
Yes, in the back.
Yes, and so what would be the remedy for prosecutorial misconduct if you can't sue a prosecutor?
The prosecutor can be administratively disciplined, fired. The prosecutor or police officer with perjury might be criminally prosecuted, though we know from experience it's very difficult to get convictions in such cases. But for the victim who suffered, there isn't a remedy. If a prosecutor knowingly uses perjured testimony and convicts an innocent person, there is no ability to sue. You can't sue the prosecutor who did it. You can't sue in all likelihood the local government that employed the prosecutor, because you're not going to prove that the local government had a policy responsible. And if the prosecutor is an arm of the state has sovereign immunity. So here, the effect of immunity is to mean that injured people don't get compensated, and also if there's no liability, you don't have the deterrent function that comes from when entities are held liable.
Does your critique of the Supreme Court affect your ability when you represent clients in front of the Supreme Court?
I don't think the Supreme Court pays much attention to what I have to say. I'll give an exception to that took me by total surprise. In March 2014, I wrote an op-ed in the LA Times saying that Justice Ruth Bader Ginsburg should step down this summer. I said, it's quite possible the Republicans are going to take the Senate in November 2014, which we now did. And there's no way to know what was going to happen in November 2016 who's going to win the presidency. And I said, the one way she can ensure that somebody with her values and views takes her place is to step down this summer And President Obama has a Democratic Senate and get anyone he wants to confirm. To my incredible surprise, Justice Ginsburg gave many interviews which said, some, such as Erwin Chemerinsky, step down, and he's wrong and I'm not going anywhere. And I'm astonished at any time, why should she care what I have to say? If you've seen the wonderful movie RBG, at one point she says that there were some who said I should step down, and I was watching with my 20-year-old daughter, and she hit me hard.
Yes, we have time for one last question.
You mentioned the Boulder case a little while ago. In the 1960s, the Voting Rights Act was passed, signed by President Lyons Johnson. Section 4 and 5 prohibited any state which had a history of discrimination in voting, discrimination against minorities. The Supreme Court said we don't need this anymore because we now know all discrimination of this type is gone. So the requirement of pre-clearance before any state made a change is unconstitutional and will not be enforced any longer. Within 2 years from that decision, the 9 states which were subject to Section 4 and 5 have all passed laws making it more difficult to vote. And we see what's going on in Georgia now and in North Dakota. Do you see any chance that the court, if the case came up, might say, well, our expectations were proved wrong, discrimination still exists, and so we're going to reinstate Section 4 and 5?
One of the myths of the last half century is that liberals favor judicial activism and conservatives favor judicial restraint. In the case that you point to, is a decision called Shelby County versus Boulder. And it involves Sections 4 and 5 of the Voting Rights Act, the requirement that jurisdictions with a history of race discrimination voting get pre-clearance. It was passed by the Senate virtually unanimously, with only 33 no votes in the House, the extension of it. President George W. Bush signed it. It was originally passed in 1965 and then reenacted most recently in 2006. The Supreme Court, in a 5-4 decision, declared these provisions of the Voting Rights Act unconstitutional. Chief Justice Roberts wrote for the court. His opinion was joined by Justice Scalia, Kennedy, Thomas, and Alito. Chief Justice Roberts said the problem with this is this violates the principle of equal state sovereignty under the Constitution. Under this, Congress has to treat all states the same. And Congress isn't treating all states the same because it's saying jurisdictions with a history of race discrimination voting have to get approval from the Attorney General before they change their elected systems. I would challenge anyone to find anything in the Constitution that says that there's a principle of equal state sovereignty, that Congress has to treat all states the same. Now, I'm not an originalist. I don't believe the meaning of the Constitution is determined by what the framers understood. But if anything is clear, it's that those who wrote and ratified the 14th and 15th Amendments didn't believe that Congress had to treat all states the same. That's the same Congress that passed the Reconstruction Act that created military rule over the former rebel states. Nonetheless, the Supreme Court creates this principle and uses it to strike down a federal statute that was passed first in 1965 and almost unanimously reauthorized by Congress. Hard to think of a clear example of judicial activism than that. And as you point out, that the 9 states that had to get pre-clearance under Section 4 of the Voting Rights Act immediately responded by adopting more restrictive laws with regard to voting or districting that otherwise never would have been approved. And so I think not only is that case important for our political system, but I think it also belies the idea that liberals are the activists and conservatives are engaged in restraint.
Please join me in thanking Dean Chemerinsky. Please join join all of us outside for a reception. Thank you all for being here.